Welcome, everyone. We are pleased you could join us today for our presentation on the New York Department of Financial Services cyber requirements. For those of you who don't know me, my name is Raj Day. Looking at the registration list, I think I've had the pleasure of working with many of you over the years. But by way of background, I serve on Mayor Brown's Global Management Committee and chair our cybersecurity and data privacy practice globally. I've been at the firm since 2006, on and off, having come and gone from some roles in government, at the Justice Department, at the White House, and perhaps most relevant for cybersecurity as the general counsel at NSA, the National Security Agency, for 3 years prior to coming back to private practice. Today's topic couldn't be more timely. As you all know, just 2 weeks ago, New York DFS published updated proposed amendments to its cybersecurity regulation applicable to financial services companies. The regulation would significantly expand a host of requirements, including new requirements for larger companies, additional governance requirements, and expanded incident notice and compliance requirements, among other things. I'm pleased today to introduce 3 of my partners to discuss this topic. First, our primary speaker and newest addition to the team at Mayor Brown, Justin Herring. Justin is a partner in our New York office and in our cybersecurity and data privacy practice. And his experience couldn't be any more timely or relevant. Justin is joining Mayor Brown, having just stepped down as Executive Deputy Superintendent of the New York DFS, where he supervised the cybersecurity division. So for those of you keeping track, that means Justin oversaw the team developing and enforcing the regulatory framework we're going to be talking about today. Prior to joining DFS, Justin served as an assistant United States attorney, prosecuting a range of crimes, of course, but including cyber crimes, both in New Jersey and in Maryland. Second, I'm pleased to introduce Jeff Taft, whom many of you may be familiar with. Jeff is a partner in Mayor Brown's financial services regulatory practice, as well as our cybersecurity and data privacy practice. Jeff focuses on regulatory compliance and privacy counseling for many of our financial services clients. And finally, I'm pleased to introduce Stephen Lilly, a partner in our cybersecurity and data privacy practice. Stephen focuses on a range of cybersecurity matters from incident response, regulatory compliance, and vulnerability management across a range of industry sectors. His background is in litigation and policy related to cybersecurity, having served as chief counsel to a Senate Judiciary Subcommittee with responsibility for enacting cybersecurity legislation concerning information sharing and liability protections. So with those introductions, I'm going to turn the floor over to my partner, Justin, who's going to preview the agenda for today's presentation and then dive into the discussion. So Justin, over to you.
Good afternoon, and thanks, Raj, for that kind introduction. And thank you all for joining us here today. So these rules will have a significant impact on cybersecurity and compliance. And our goal here today is to help you understand what that impact will be on your company and to help you prepare for the changes and the new requirements. We've organized the substantive conversation into 5 sections, right? Governance and policy, expanded program requirements, incident response, new requirements for large companies, and finally, a heavily revised enforcement provision. Now, if you have any questions during today's webinar, you can enter them into the Q&A box at the bottom of your screen. Please be sure to include your email address. Anything you type into the Q&A box will only be visible to the presenters, not to the rest of the audience. Of course, you are welcome to interview myself or any of the presenters from the firm today if you have questions as well. Today's program is being recorded. In the next few days, you'll receive a link to this recording along with a link to the presentation materials, the PowerPoint, which you can download. We're very much interested in getting your questions, but we are not planning in the interest of time and efficiency in answering those questions today. We are planning to circle back with folks who provide questions, and once we get a chance to see them, if it's appropriate, we may also put out a blog post or even follow-up webinar. We'll make that decision, I guess, once we've got a chance to see how many questions there are and what they are. So I'd like to start today, before we dive into the substance, talking a little bit about the DFS's cybersecurity rule and the amendment process that's been going on for more than a year now. Now, if you're here at this webinar, you're probably already familiar to at least some extent with DFS's cybersecurity rule and the fact that the department has been publishing proposed amendments to that rule. But just to level set, let me take a few minutes to describe the rule in its current form and the proposals that have brought us to the final proposal that we saw a couple weeks ago. DFS's rule on cybersecurity regulation have played an important role in the financial services market because they were the first comprehensive and mandatory cybersecurity regulations issued by a US financial services regulator. Today, there are a web of statutes, regulations, and guidance documents on cybersecurity that apply to financial services companies. Many of those have been adopted in the years since DFS's regulation was issued and have served as a, and have in many cases followed DFS's regulation as a model, in some cases explicitly, in other cases implicitly. Jump ahead to the slide here. DFS's current regulatory framework emphasizes starting with a comprehensive risk assessment that identifies the key risks faced by organizations and steps to mitigate those risks. The regulation requires documented policies and procedures addressing many different areas of cybersecurity, from access controls to incident response to third-party risk. So the amendments that we're going to be discussing today are pretty comprehensive. There are amendments to most of the sections in the current cybersecurity regulation. The proposed amendment builds out on some of the existing requirements, for instance, by expanding governance requirements. And the proposal also has new provisions that create new requirements in areas such as asset inventory and business continuity planning. So the formal amendment process has been going on now for almost a year, right? And the language that was published 2 weeks ago, the proposed amendment from DFS, is actually the third time in the last year the department has published proposed amendment language for an amendment. And if you're interested in understanding the department's thinking behind some of this, there were also statements by the department, for instance, a ransomware guidance in 2021 that expressly referred to controls that could be incorporated into a future amendment. And some of them have, in fact, been incorporated into the proposed amendment that we're discussing today. Now, from the pre-proposal version in July of last year to the current version, almost every provision was edited, rewritten, or in a few cases, simply deleted. Now, for the most part today, we're going to focus on the current proposal. That's the language that is out there for notice and comment. It's the latest language, and it's most likely to reflect what's going to be in the final rule. There are a few places, though, where we will address the language in the prior proposal. As a practical matter, it can be helpful in some instances to look at how the language evolved between proposals as an indication for how the department is likely to interpret its regulation or apply it once it's final. One example of this, right, is change in the language on the requirements for board competence in cybersecurity. Prior proposed amendment language required boards to have, quote, sufficient expertise and knowledge to oversee cybersecurity risk. But in the most recent proposal, that was changed to require that boards have a sufficient understanding of cybersecurity related matters. Right there, we can see the removal of the word expertise, and we can reasonably infer that shows the department is backing away from a mandate that the board have experts or be experts on cybersecurity in favor of what is, for practical purposes, a slightly softer standard that they have sufficient understanding of cybersecurity to exercise their oversight. Looking forward, we should expect that there'll probably be fewer changes between this version and the final rule. That would be consistent with major regulations in the past issued by DFS, including the original and current cybersecurity regulation. That regulation, the original regulation, which was first published for notice and comment in 2016, went through 2 rounds of notice and comment. But in the second round, there were far fewer changes between the second round and the final version. And if you're trying to understand when the rule might come out, it is helpful to understand that in the New York administrative law does require that regulatory amendments be finalized within 1 year of the date of their formal proposal. Here, that would be November 9th, 2023. Now, this isn't a hard deadline, and it's just based on the administrative rules and past practice. Of course, a regulator can always repropose a rule or seek to extend that period. But generally, as a historical matter, again, for instance, when the original cybersecurity regulation was published for notice and comment, you can see this DFS and other New York State agencies have made an effort to try to get rules finalized within that 1 year window. And here, that would bring us into early November. So let me also, before we jump into the different provisions, give you one more practical tip. If you're thinking about or want to understand how the department is likely to apply and interpret these new rules. Now, the department's cybersecurity division works with regulators inside and outside of DFS across many different kinds of financial services companies. So that means that, or earlier referenced sort of the web of different guidances and rules, right? That web is often implicated by the cybersecurity divisions, the regulatory teams work, both the examiners and the lawyers. And this often informs how they understand these areas or how they're likely to approach a new rule. Right? Let me give you a concrete example. So the proposed amendment includes requirements for business continuity planning. Right? That's a brand new requirement for DFS's cybersecurity regulation. But there are business continuity requirements in other guidance and regulations that DFS applies. For instance, FFIEC guidance for banks has a section on business continuity, and DFS itself has put out guidance on business continuity planning for insurance companies. The department's personnel have had, in many cases, years to work with these standards and to apply them, right, as have in the cybersecurity division and in the other parts of DFS. So it is reasonable to think, for instance, that the department's approach to regulatory supervision under business continuity will be shaped and influenced by the FFIEC guidelines on business continuity that many of the department's examiners and lawyers are familiar with and have been applying to banks for a number of years. Right? Thinking about that may also be useful if you are seeking to write a comment letter to the department and in the hopes of influencing the language before final publication. Because the department's personnel are likely to be familiar with this kind of specific rules that apply to specific sectors of the financial services community, it may be more persuasive to point out to the department, hey, this rule, we understand this rule exists for one kind of company. Maybe it's banks and we're an insurance company. But there are reasons why a rule that applies in that sector might not be a good fit for our sector or our companies, right? That kind of argument, I think has maybe more of a chance of being persuasive to the department because the cybersecurity regulation, after all, is a one-size-fits-all rule. It applies to all the DFS companies equally. And the department, therefore, may be susceptible or willing to hear the argument that, hey, the one-size-fits-all is not that great for this particular provision that you're considering. All right, and with that, let's turn to the governance proposals. So let's start here with the new requirements for boards. For the most part, these requirements for boards are going to be entirely new in the proposal, right? Other than a single reference to an annual report by the CISO to the board, there isn't any mention in the current regulation of specific board responsibilities in the cybersecurity area. Under the proposal, boards would be required to exercise supervision and to oversee cybersecurity risk management at the company. The board would have to have sufficient understanding of cybersecurity related matters to effectively exercise that oversight. And although this language is new to the cybersecurity regulation or new to the proposal, it does reflect sort of a long-stated view that the department has had, that cybersecurity should be viewed as an enterprise risk, as a major risk for all financial services companies. And like other enterprise risks, it's the board's responsibility to oversee the company's management of that risk and also to help set the risk threshold and the risk tolerance for the company. Now, the language in the current proposal sets out these requirements for what a board has to do. It does leave companies with some flexibility to determine how to do it. Right? I mentioned earlier that the reference to board expertise was removed in the current proposal. And that, I think, can reasonably be inferred to give the company some latitude in determining how they're going to make sure and they're going to demonstrate that the boards are in fact exercising this oversight. So Some of the ways that companies do that now are through things like training for the board, hiring of advisors, expert advisors for the board, or in some cases, actually having individuals with cybersecurity expertise on their boards. The rules don't prescribe any one of those particular paths, but I think that what the department will be looking at is whether or not the companies can show their work, right? So you're going to want, well, the way the department reviews this, right, is to look at documents. I suspect none of you are going to want to invite the department to your board meetings. So the department will assess this by looking at things like board minutes, board reports, board presentations, and other documents that reflect, what the board has looked at and what feedback or guidance the board has provided to executive management. So it's important to make sure that your board is in fact engaged on the issue of enterprise cyber risk, and also to make sure that that's reflected in the kinds of documents that the department is very likely to review. The proposed rule also requires the board to approve cybersecurity policies. And if this has not been the practice at your company, and this is going to be something that you're going to have to do once this rule, assuming that it does go into effect, applies to your company, then one way to think about this too is to tier out the nature of your cybersecurity policy and requirements. So at companies where the board does approve cybersecurity policies, either because of the company's approach or because of a regulatory mandate, right? You will a sensible practice is to make the policies that go to the board pretty high level, right? And to have underneath those standards and procedures documented so that they are documented and they can be tracked, but those details are not in the same documents that go to the board. The new proposal also adds more requirements and more definition around the CISO's role. For starters, it adds a definition for CISOs that requires that CISOs have adequate authority to implement an effective program. I think we can safely view this as a codification of the department's existing view, since a CISO that did not have the ability to implement an effective program would have been reviewed even today as an issue by the department. Another thing that's changed for the CISO is the reporting to the board. As I mentioned earlier, the current regulation, the only specific reference to reporting to the board or the board at all is a requirement that the CISO report to the board at least once a year in writing. The new regulation also states that CISO has to timely report to the board on material cybersecurity issues. In other words, the department's view here is that once a year, particularly if there are material issues that arise between annual reports, is not enough, right? For keep the board actually informed and engaged on overseeing enterprise cyber risk. One way to show that you are complying with this and are prepared to address this new requirement, right, is to have documented thresholds or issues that maybe require you to go to the board either quarterly or on an ad hoc basis, like for instance, if there's a major incident or a change in the company's risk assessment. And there are also changes to the amendment also proposes changes to the annual compliance certification requirement, right? And there's two significant changes that I want to discuss here. The first one is the requirement that certification be by both a CISO and the company's CEO, right? Obviously, the CEO is not going to be familiar with many of the details of the cybersecurity program. So most large companies will have to rely on a process of sub-certifications and internal reporting to support certification by senior executives. The proposal would also add a requirement that companies that don't certify compliance have to submit a written acknowledgement of non-compliance and identify the areas of non-compliance and the general scope of that non-compliance. Now, since 2021, it's been the department's practice to reach out to companies that have not certified compliance and request this kind of information as to why they aren't certified. Now, that process, though, often occurred many months after the certification deadline. So, for instance, the annual certification deadline is April 15th, right? So companies would be contacted sometimes in the summer and asked to explain their non-compliance. One of the key changes here is that kind of explanation will now be required by the regulation and it would be due on the same date as the certification on April 15th. So it's something that if for some reason your company is not going to be able to certify compliance, you want to get ahead. You're going to want to get ahead of that, start preparing for it, because you are going to be required to submit at least some kind of explanation to the department at that April 15th deadline. So next, I'm going to turn to my colleague, Jeff. And Jeff, can you share some of your thoughts on the practical challenges that companies are likely to face in complying with these new requirements?
Thanks, Justin, and appreciate that lead in. I think that was great. I think one of the things that makes the DFS regulation particularly challenging is that it covers a lot of different types of covered entities. And each of those types of covered entities, whether you're a bank, you're an insurance company, or you're a non-bank financial services company, you may have different governance procedures, and your regulators in those spaces may have different requirements and expectations. I think, as you said, Justin, I mean, if you're a large bank or if you're a banking organization, you're subject to FFIEC and all the other requirements. It's probably fairly standard for the board to be approving, or a committee of the board to be approving some of these types of policies that we're talking about today. I mean, for example, it's required under the GLBA safeguarding rules that the banking regulators put out that the board or the committee of the board would approve those. So I think for some of the banks, this requirement of approval may not be a big deal. When we talk about board here, we're also talking about really what the regulation calls the senior governing board, which for most companies is really the board of directors. But if you're somebody like a branch or an agency of a foreign bank, that's likely we don't have a board of directors per se. It's likely going to be some sort of management committee or somebody like that who's going to be approving those types of policies. So I think that's something to kind of keep in mind. As Justin said, I think everybody's going to have to take a look at their existing policies and procedures to determine who in fact has approved them, or have they been approved, and who did that approval. Was it an officer, or was it somebody below the board? And you may have to go back, obviously, as Justin said, and redo those approvals. So I think that's an important aspect that people need to kind of keep in mind when they're thinking about what they need to do to kind of come in compliance with this new regulation. And for larger organizations, which have really very regimented board schedules, you need to get that on the calendar, obviously, because that will be a difficult thing to get on the calendar. I think one of the things that Justin noted, I think highlights something that we see in all financial services right now, is we see much more regulatory expectations that the board is going to be on top of issues. The board is basically overseeing, which is their role, obviously, and a lot of what the DFS is telling the board to do here is part of generally what I would describe as good board governance, right? But it's actually being put into the regulation, so it's something that obviously has to be done as a matter of complying with the regulation. So I think that's kind of important at this point to kind of understand that. The certification process to me is also something that I think is very interesting. For years, we've had clients say, well, who should certify? The regulation's not very prescriptive. It gave us all this leeway to decide which officer or director or whoever should certify on behalf of the company. So we spent a couple of years, and now they've decided to make it much more prescriptive. The one thing I would say, and I don't know everybody's CEO, obviously, but I do know that when CEOs are certifying, they tend to be obviously a little bit more divorced from the day-to-day cyber management, unlike a CISO or somebody like that who's dealing with it on a regular basis. And we have seen those CEOs basically asking for a lot of backup documentation with respect to the certification they're going to make. And as Justin alluded to, that often takes the form of sub-certifications and things of that nature. Now, in smaller companies, obviously, that may not be a big deal, but in large financial services organizations where there's very diffuse responsibilities, I think you're going to see that. So that is something that people need to have in place. If you do not currently have a CEO who is one of the people who is certifying, I think you're going to have to think about that process, think about what the CEO is really going to expect, and probably have some discussions around that, because that's going to be a very important process that you're going to need to put in place well before it's time to certify. And obviously, that's something that is a hard, fast deadline, April 15th now in the statute or in the regulation. So that's something you have to kind of keep in mind in doing that. On the CISO side, I think one of the other things to kind of keep in mind is I think people are going to actually have to go back based on the definition now and look at their CISO and see whether their CISO is a qualified individual, I think in a lot of smaller organizations, people got dual-hatted or tri-hatted as a CISO because they were the chief compliance officer. They had some other role. I think it's important that you kind of go back and examine that. I also think that this definition talks about the CISO having adequate authority to ensure compliance risks are appropriately managed. And that includes basically the ability to get funding to address issues. And I'm not sure that all the CISOs have that type of authority right now. So I think that's something obviously that people are going to have to go back as a practical matter and look at. And again, I think it's going to depend really upon, part of what industry your company's in. Are you a bank? Are you an insurance company? Or are you a non-bank financial services company? That may have some impact on how you currently have your CISO and the size of the company. So I think, those are some of the kind of the practical highlights I think about, some of these changes that you talked about in the governance requirements. So let me kick it back to you, Justin.
Thanks, Jeff. Yeah, appreciate those comments. All right, let's move on here and let's talk about some of the new policy requirements. In addition to new governance requirements, generally, the new regulation does require policies that address, the proposed amendment would require policies that address more areas, right? And these, you can see them on the screen. They're data retention, along with asset inventory, end-of-life management, remote access, security awareness and training, systems and application security, and vulnerability management. Now, some of these are already addressed in the existing regulation. They just were not listed in the section of required policies, right? 500.3. And many companies are likely to already have policies that address some or maybe all of these areas. Some of them are addressed, like I said, they're addressed elsewhere in the regulation, like vulnerability management and policies around data retention. Others, like remote access, are areas that have taken on renewed importance in recent years, or greater importance in recent years. Again, depending on, you're going to want to review the policies that you have and determine whether these areas are covered. And if they are covered as well, make sure that you can clearly identify where they're covered and how they're covered. Again, when the department is conducting an examination or even potentially an investigation, right? One of the things that they will want to see is in the documentation, some sort of clear reference to the specific areas that are required, in which the company is going to be required to have policies. All right, so next we'll move on to incident response and incident response planning. So under the proposed rules, incident response planning will have to include plans to recover from backups, right? And taken in conjunction with some of the rules in the business continuity section, which require companies to have backups from which they can recover, right? I think this represents an emphasis in the regulation on having backups that companies can use to recover from in the event of a destructive cyber attack, like a ransomware attack, or even a natural disaster, right? I think in other contexts, in other regulations, business continuity has always been a priority for financial services regulators, right? Like the FIC guidance we've mentioned a few times, but on the insurance side as well. And the amendments would bring some of those kinds of requirements, the business continuity type requirements, into the cybersecurity regulation as well. And the department has stated, as of other financial services regulators, right, that a lot of this is driven by both the rise in destructive ransomware attacks. When the DFS's regulation was first crafted in 2016, ransomware, the idea that ransomware could shut down a bank or insurance company was still somewhat science fiction-y. That is obviously no longer the case. And also the concern, regulatory focus that you've seen all the way from the Federal Reserve and across state regulators like DFS, that cyber attacks could pose a threat to the stability of the financial system, has made this a focus. And you'll see that in different statements from DFS and from other regulators. So that's one of the requirements here in the incident response plan. The other two requirements in the planning part, the incident response planning part, have to do with post-incident updates to the incident response plan and a requirement for root cause analysis after an event occurred to determine what can be done to prevent recurrence. These are also steps that many companies I think are going to take after an incident happens. But one of the changes that you may want to examine in light of these proposed rules is whether or not that's actually formally incorporated into your incident response planning. Now, with respect to the new requirements for incident notification, there are several different new notification requirements. The first one is the requirement to notify DFS in the event of an incident that results in the deployment of ransomware on the company's information systems. Right. Second, you'll be required to notify DFS where an unauthorized user or hacker gets access to a privileged account. And those two requirements, and again, the department has said this, are designed to ensure that certain kinds of serious incidents that are being reported to the department, again, reflecting the department statements all the way back to the guidance on ransomware in 2021, that these are very serious incidents, and the department wanted to make sure that they were all being reported, and that they weren't slipping between they weren't going unreported because the existing requirement that only requires reporting when there's a material disruption to business operations or another statutory or regulatory notification provision is triggered. There's also a requirement here to provide any information requested to DFS and to provide updates. Some of you may know the department has developed a practice in recent years of following up and requesting additional information when incidents are reported. And the insertion of this regulatory, I think we can assume that the insertion of this clause here is related to that follow-up. The notification requirement for third-party incidents. The department has said in some of its statements that it believes the current regulation does require notification to the department when there is a third-party incident, but rather than leave it implied or a matter of guidance, they put it into the current proposal. Finally, when it comes to notification, there is a new proposed rule for notification of extortion payments. Specifically, this would require very quick notice to the department whenever a company makes a cyber-related extortion payment, almost always a ransomware payment. And within 30 days, it would require the submission of a written statement to the department that explains why that decision was made, what alternative options were considered, and what diligence was done around sanctions, around OFAC sanctions, determining whether or not the recipient of that payment, the cyber criminals, were under sanctions. That's a potentially significant new requirement, especially because it will be happening on a relatively quick timeline. The notification to the department that a payment has been made is going to be required within a day, and then you will have 30 days for the written notice. So I want to turn to Stephen, who has tremendous experience helping companies manage these incidents, and ask him about the impact that these rules are likely to have on incident response and incident response planning.
Yeah, thanks very much, Justin. It was a great overview, and I think a few takeaways that I'd offer. The first, as you mentioned, a lot of these incidents would be reported anyway under the existing rules, but practically speaking, I do think you're going to see an increase, at least in the first-party incidents, so the incidents that a company experiences itself, that will lead to notification to DFS. A couple, one particular stands out. There are going to be incidents where you've lost control, however briefly, of a privileged account. That now is a per se trigger for under this proposal would be a trigger for notification to DFS, even if there wasn't any significant impact, for example, because you quickly disabled the account or prevented any malicious activity from occurring. The ransomware piece, that does have materiality requirements for deployment of ransomware with a material part of the covered entities information system. So, likely that would have triggered notification anyway. But I do think overall there's going to be, some increase in the scope of incidents that are going to require notification to DFS. That will, there'll need to be a corresponding check, assuming this goes through as proposed, to your incident response plan to make sure that the types of definitions and triggers you have for internal escalation are appropriately calibrated to the legal obligations that you have. For example, there's a new requirement that I think Justin mentioned about notification by the CISO to the board of major events. Obviously you'll want to make sure that there's an appropriate tether in your plan to that type of escalation, so you can meet any such obligation that does get imposed in the final rule. And then there are sort of connections back to the from the incident response obligations back to the underlying obligations. So, for example, going back to the idea that there are going to be requirements to notify about access to a privileged account, there's also an obligation to limit the number of privileged accounts and how they're used. Obviously, there's a further incentive if you're going to have to report such an incident to go back and make sure that you do reduce the number of privileged accounts to the extent possible. And in the same way, certainly this reporting requirement, I think, would encourage further network segmentation or other technical tools to reduce the risk of a deployment of ransomware that affects a material part of your information systems. And then also just to talk for a moment about the notification requirement for third-party incidents. These third-party incidents we've seen be particularly challenging for companies because you lack control of the investigation, you may have very limited information, and you may, as a result, not be able to answer even the most basic questions from your customers or your regulators or what have you. We've also seen that for some companies, these third-party incidents, they can be a bit of an awkward fit and are not fully accounted for in incident response plans. So that's something to look to, I think, in the coming months. Because going forward, I think you should expect that your peers are going to be notifying DFS about, say everyone's got a common supplier, and that's going to put pressure on you to notify DFS, likely before you know what the impact is going to be, and likely before, in some cases, before you can answer some basic questions. And that in turn will, probably make it even more important than it already is to have appropriate contractual requirements in your vendor agreements that require prompt notification to you about incidents, fulsome sharing of information, cooperation, those types of provisions to the extent that you can negotiate them. And then finally, just really quickly on the extortion payments notification, this certainly sounds is part of a trend we're seeing that Congress passed the Critical Infrastructure Cybersecurity Reporting the Critical Infrastructure Act. That also has a ransomware payment notification obligation that's going to go into effect in the coming years through regulation. I think one thing that's really notable here is that the written summary it's hard to, and I'm sure that with good lawyering, you will be able to find a way to write it to reduce the risk as much as possible. But one of the reasons, you have to write why payment was necessary. In many cases, that will be because you weren't able to restore from backups. Now there's a regulatory obligation essentially to, or there would be if enacted as proposed, to have the ability to restore from backups. So essentially, this written, explanation could put you in the position of essentially having to choose between not being able to recover as quickly as you want to, and with the hard choice of potentially facing regulatory exposure by essentially having to tell the regulator you didn't have the capability to restore from backup that perhaps the regulator may think you should have had. So that's just this is all part of a trend that feels like of encouraging or discouraging payments and putting companies to harder and harder choices about making such payments. But with that, Justin, back to you.
Thanks, Stephen. All right, so let's switch now to business continuity requirements. So the new regulation does have a essentially entirely new subsection on business continuity and disaster recovery planning. Right. I think the impact of this provision, this proposed subsection, to some extent will depend on what the kinds of requirements that your company is already subject to. As I said, part of the web of regulatory requirements that financial services companies face, a number of companies already face requirements in this area. And essentially, these do require detailed business continuity plans to ensure that the company is able to continue to operate and protect personnel and assets in the event of a cybersecurity related incident. And I should note, I think this is worth noting here, that before the current proposal, this subsection was written in such a way as to make the CISO responsible for all business continuity. The most recent proposal qualifies that by specifying that the business continuity requirements of the cybersecurity regulation would apply only to continuity from cybersecurity related incidents or disruptions. So finally, in this section, I want to talk about a few of the requirements that are relevant to both incident response planning and business continuity. Right. Some of these are fairly granular, like making sure that the plans are accessible during an incident in which the technology systems may not be accessible. I believe in its ransomware guidance, the department pointed out a number of incidents that were reported to the department where the plans turned out not to be useful because they were stored on the same systems that the company had lost access to. So you want to make sure, I mean, this is basically a requirement to have hard copies of the plans, right? That the employees responsible for implementing the plan have the training necessary to implement their role in the plan. And the next one is a big one, testing of the plans, both the incident response and the business continuity plan, to the extent that they're separate, with senior officers and the senior officer, usually the CEO, at least annually. And again, as I mentioned earlier, the department's view on preparedness and planning has heavily emphasized testing. And that's reflected by the requirement for testing here and elsewhere in the regulation. And I think we should expect that'll be something that the department will be monitoring in its supervision if and when this proposal becomes final. And I've already discussed backups and the testing requirement there as well. But that is, as Stephen mentioned, right, an important factor here, and the way it interacts with the incident reporting requirement and the ransomware extortion payment requirement. It's intended, the regulation as written, right, is intended to require necessary to restore critical operations, and that the backups have to be adequately protected from alteration or destruction. All right, so next I'm going to shift to expanded cybersecurity program requirements. So we'll start here with a big one, and that is the requirement essentially for multi-factor authentication all the time. The existing regulation requires multi-factor authentication for remote access and where it's appropriate to use multi-factor authentication to mitigate cyber risk. The proposed regulation would strengthen that requirement considerably by imposing a requirement for multi-factor authentication for all user access. So that would be irrespective of the type of access and whether or not it was remote. This could be a significant change for many organizations in that it would require not just policy changes, but may require upgrades or changes to the technology platform. Notably, the department's provision on transitions states that this multi-factor provision would companies only going to be required to comply with this starting 2 years after the effective date of the amendments. And that window, however, can seem awfully short if you have to implement new technology to allow for the use of multi-factor authentication for every user access to your information systems. So again, this is going to be one of those areas where as this rule becomes final or is likely to become final, you're going to want to get ahead of planning on this and seeing what changes you have to make in your actual technology infrastructure to get into compliance with this. So next we have access controls. There are several new requirements around access controls in the proposed regulation. Most of these, I think, can fairly be described as embodying the principle of least access privilege, right? Which requires that each user only be given access necessary to perform the user's job, right? That those kinds of accesses be periodically reviewed and disabled or terminated when they're no longer needed. This is going to be a governance challenge, right? An operational and auditing type governance challenge to make sure that not just the companies have a policy to do this, but that they're actually implementing it. Given that the roles, hires, and departures can happen on a regular basis, I think this is going to be an area where it's going to require not just sort of a documented policies, but actual implemented governance and a process and a system for making sure that user accesses are reviewed regularly. Finally, the regulation would specify that in this section that to the extent that passwords are used, the company must have a written password policy that meets industry standards. To the extent that passwords were used was added in the most recent proposed amendment. It is the case that a number of companies are starting to move away from passwords as an authentication technology. So this rule also has some built-in flexibility if a company is moving towards something like a FIDO authentication standard that is passwordless. So some other requirements in the new amendment, right? First one would be asset inventory. And this is also, again, it's both a technology and a governance requirement. Understanding like what assets a company has, technology assets it has, can be very challenging as a practical and technical matter, right? A lot of technology assets can't be touched or seen. They are virtual only. And many companies, if they don't already have them, are going to need tools to track digital assets, especially virtual ones, in order to comply with this requirement, as well as more processes or governance in place to make sure that these inventories are regularly updated and that issues like end of life date and recovery time objectives are accurately tracked and periodically updated. The proposed regulation would also require cybersecurity training to be at least annual and to include training in avoiding social engineering attacks. It would require, it has expanded requirements for vulnerability management, including requirements for some automated vulnerability scanning of the information systems at some regular frequency, or whenever there are material changes to the system. There's also now an express requirement that vulnerabilities be timely remediated based on the risk that they pose. And so now, given the complexity of many modern systems, obviously vulnerability management is a major challenge for most organizations, both the complexity and the fact that new vulnerabilities are discovered on a monthly or sometimes it seems daily basis. So Stephen, I wanted to turn to you and ask you if you could share some thoughts on how companies could get ahead of these kinds of vulnerability management mandates.
Yeah, absolutely. I know this will be an area where your companies are already active and working through this issue, but obviously with the overlay of specific regulatory requirements, some of the decisions you make suddenly take on even greater significance from a legal perspective. There are a lot of complexities. One of the common themes that I see across many of the complexities that companies face and challenges companies face in these programs is around the concept of severity rating. So, that drives prioritization. It drives escalation of issues to the board and senior management. And just to give an example, if you use the CVSS scoring system, for example, which is the technical vulnerability scoring system, that may give you a rating that is actually not doesn't really tie to the business impact. So if you may have you may have an open door on a system, but the system may not have very sensitive data on it. It may not be your biggest priority as the business, but it may have a very high security rating. So you have to think through, how do you want to rate these issues? How do you want to prioritize the way that you address them? And if you're going to have an overlay of sort of business considerations, how do you do that in a way that can be repeated, that doesn't introduce too much subjectivity, and that can be defended either in private litigation or in a subsequent regulatory action? So that's just something to think about as you go from operating one of these programs already, which I suspect is what you're already doing, to thinking about how you would ensure that the way you operate it would meet regulatory expectations. So thanks for that, Justin.
Thanks, Stephen. Finally, on this slide, I'll just mention that there is also a expanded penetration testing requirement in the proposed amendment, right? That would be required to be at least annual and to be conducted both from inside and outside the company's network. right, next I'm going to talk a little bit about the requirements that are in the proposed amendment for large companies, right? What the amendment refers to as Class A companies. I'm going to start with the criteria for Class A companies. That is, the company has at least 20 million in New York revenue, and either $1 billion in total revenue or 2,000 or more employees. So that would exclude companies, the first provision, at least 20 million in New York revenue, would exclude companies that are licensed by the department but have only limited operations in New York. The other two criteria are pretty straightforward, right? Revenue and employee count. One thing to keep in mind when considering this is that those numbers include affiliates, right? And affiliates is can be one of those tricky terms because it's defined in different ways in different regulations, even within DFS. So for purposes of the cybersecurity regulation, affiliates include any companies that share common control. It's an expansive definition, right? It's a defined term in the cybersecurity regulation. So when you're calculating whether or not you have $1 billion in total revenue or 2,000 or more employees, you are also required to include other companies that share common control. So the most common case where this comes up is you have a DFS licensed subsidiary, but the corporate parent or other parts of the corporation are not licensed by DFS. Under the affiliate rule, they would all have to be counted for purposes of these thresholds, unless, and this is some new language in the current proposal that wasn't in the last proposed language, unless those affiliates don't share information systems, cybersecurity resources, or cybersecurity programs with the DFS licensed entity. But otherwise, you have to count essentially the whole corporate family for purposes of these thresholds. All right, and so what are the requirements facing Class A companies? At this point, there are 4 significant ones in the proposed amendment. There were a few other ones that have dropped out over the last couple of rounds, but what's left is a requirement, an annual audit, independent audit for the company's cybersecurity program. And the one change from the last proposal is this audit can use personnel that are either internal or external to the company. In the prior proposals, this was required to use external auditors, but there's some more flexibility in the current language. Larger companies are also required to have endpoint detection and response systems, and also SIMs, which are systems that allow for centralized security logging and alerting. And finally, they're required to have privileged access management, automated tools for privileged access management for the management of privileged accounts, and to use tools that prevent users from using very common passwords like the ever popular password 123. You know, we're running, we want to be respectful of everybody's time, so we're going to keep things moving here to make sure we are done in the next 5 minutes, right? This is the last substantive section, right? And it's the new enforcement provision. Now, the enforcement provision was a single sentence, is a single sentence in the current regulation. And the proposed amendment would write it to have 2 fairly significant sections. The first one defining a violation as either a material failure to comply with any section of the regulation for 24 hours, or the failure to secure or protect an individual or entity's non-public information due to non-compliance with the regulation. And it would also add mitigating and aggravating factors for the department to consider in the event it was investigating or pursuing a violation. Now, these factors are largely copied from factors set forth in the New York banking law, and they're being incorporated. The main effect of incorporating them in cybersecurity regulation is that they would then apply to all companies regulated by DFS. And the DFS has already stated that these are the factors that it will consider when deciding what resolution of an enforcement action is appropriate. And so this is essentially a codification of what's in the banking law for all DFS regulated companies. The one thing that's not in the banking law is it will also consider the extent to which companies' policies and procedures are consistent with nationally recognized cybersecurity frameworks such as NIST. Consistency with an established cybersecurity framework could be considered a mitigating factor, right, in evaluating an enforcement action. And I'll just say in brief here, since the enforcement subject could be its own separate webinar, after once the regulation had been in place for a few years, and really starting in 2021, the department started to actively enforce its cybersecurity regulation. And since 2021, in the last 2 years, there have been 10 published enforcement actions resolved by the department, where the consent agreements were published online. And there are some consistencies across those matters, like just at a very high level. Several of the matters include charges of false certification, false compliance certification. Several of the incidents also involve charges of failure to report an incident required under the notification provision. And a number of the incidents fall within the fact pattern of some kind of significant cyber incident occurring at the company. And one of the gaps exploited by the attacker was a lack of effective MFA that was required by the regulation, right? So if you're looking for some of the trends in the enforcement actions, those are 3 that I can highlight quickly. And Jeff, I want to turn it over to you, right, to help us bring this thing home and share with your thoughts on what these new regulations are likely to mean on the enforcement front.
Well, I think one of the interesting points is they've actually defined what a violation is. I know a lot of clients had asked that question. The regulation wasn't very prescriptive, and to be honest, now that it's prescriptive, I'm not sure people are going to like it. So 24 hours of material failure to comply with the regulation seems relatively draconian, but I digress for a second there. So I think that's one thing that people are going to look at, because that happens. That could happen. Somebody leaves a system open, or somebody leaves a back door open, or something like that. You could certainly have a violation at that point. So that's something that there's clarity on now that people are going to have to be aware of, because that obviously is going to trigger potentially notification, or not able to certify, or to have to certify and acknowledge that there was a violation. So I think that's the most interesting thing. I think the mitigating and aggregating factors are things that every regulator or the DOJ, everybody has those. If you cooperate, you get better treatment, and so on and so on. I don't think that's anything unusual. People should just hope they don't find themselves in that situation. Turn it back to you.
All right, thanks, Jeff. And I think with that, we are reaching our conclusion here. So thank you all for joining us. I hope this was informative. It was really a pleasure and an honor to be able to share our thoughts with you. If you do have questions, as I said, we will have a transcript of questions that were put into the Q&A. If you think of questions afterwards, please reach out to really any of us on the panel, or you can email them to the address shown here on this slide. And I looked quickly at the Q&As. I already saw a couple questions, so I will reiterate. Within a couple of days, we'll be circulating a link to the recording and to the PowerPoint, this PowerPoint presentation that we've shown. So you'll be able to get, a copy of it. And with that, I'm going to turn it over to Raj for parting thoughts.
Thank you, Justin. Thanks to all of you for joining us today. Thanks to my partners, Justin, Stephen, and Jeff, for that fantastic presentation. And this is just the start, I think, of a discussion on these proposed regs, amendments. So stay tuned and have a great afternoon. Thank you, everybody.